So, namaste, good morning. As usual, it has become our habit now to come and be connected with all of you. Today, we are conducting our 47th episode of AAA webinar series. And the subject that this time that we have chosen is the information utilities. As we understand in the proposed amendments, which was on the public domain on 18th of January 2023, and in that notice from Ministry of Corporate Affairs, we also could understand that the role of information utilities are going to be increased. The record of default that would be used from IU only, and only in very, very special circumstances, the adjudicating authority will go for other records. So with this kind of objective, the use of information utility by various professionals, insolvency professionals, chartered accountants, lawyers, all this is increasing now. The liabilities and assets all can be verified from the information utilities. And our today's webinar, we have also the pleasure that Mr. Deba Jyoti Ray Chaudhary, the Managing Director of NESL, the National E-Governance Services Limited, the only company which is handling information utility in India. Presently, there is only one IU in India, and that's what is being managed by NESL. And Mr. Chaudhary is the Managing Director of this company. This is a company which is fully owned by banks and government. So before we even go and before we start on our PPT, I will ask Mr. Chaudhary to give opening remarks. Then we will go through the contents of the PPT, and then we will discuss the future perspective, the proposed changes, and how the insolvency professionals can use IU on regular basis. Mr. Chaudhary, thank you very much for joining this AAA web series, and we welcome you to this series. The endeavor is today to make our participants to understand IU more and more, and so that they could start it now before even the amendment is live. Yes, Mr. Chaudhary, what would you like to say to our audience?
Yeah. Thank you, Anilji, and good morning to every one of you. Good morning, Ankitji. First of all, I would like to thank Ankit, Anilji, and AAA Insolvency for having me here at this webinar. I think this is a very useful series of webinars, and earlier I used to attend it. I somehow lost touch after joining NESL, but I remember I used to attend this very regularly when it was initially started. So I'm happy that this session was on information utility. In fact, only last week I was there in the International Research Conference, where also I spoke about information utility and how this is a very, very unique Indian innovation. And I would also like to quote our Honorable Prime Minister Narendra Modi ji, who has said that this is Amrit Kal, and in Amrit Kal, India will give directions to the world. So like UPI, information utility is another unique Indian innovation. And yesterday also I was in IIM Bangalore, and we had a representative from Germany, and he was very interested and very curious to know that how this information utility works. So this is something which is very unique to India, and the way it has been conceptualized, it can play a very important role in the resolution process. So I'll just take a couple of minutes and tell you what is so unique about this. So the most unique thing about the about the information utility is that the way the information is stored in the information utility. So the moment a bank or any financial creditor, operational creditor submits information to the IU, this information is presented to the debtor. So the debtor has three options. He can accept it, he can dispute it, he can of course choose to ignore it. And this last segment is likely to be addressed in the amendments to the code which Mr. Goel referred to earlier. But even before it's addressed, Mr. Goyal is also in this presentation is dealt with an important case law, Whipple versus Teco Industry, where the AA said that if a debtor does not choose to respond to the invitation to authenticate of an information utility, then he cannot dispute the existence of a debt. So IU is an equitable institution. It gives an opportunity for the debtor to give his views. He can accept it, he can dispute it, but if he chooses to ignore it, so he may not be able to deny the existence of the debt at a later date. So that is the first unique part of the information utility. The second unique part of it, and there Mr. Goyal also talked about how this could be useful to the IPs, and I'll dwell partly on that, and I'll be there later on also. So information utility gives you push notification at various life cycle events in the insolvency resolution process. First notification goes when there's a default by a debtor to one creditor. So all creditors come to know after the IU has done the authentication and verification. The second notification goes when an application for insolvency has been filed by one creditor. So other creditors come to know that insolvency application has been filed, and so they can take steps to protect the interest. And finally, the third notification goes when there's initiation of insolvency and public announcement is made by an IP. IBBI passes the information to us, and we advise all creditors who are registered on a platform that public announcement has been made. Please do file your claims with the insolvency professional. So there's a second unique feature. Third unique feature is that this is the only credit repository in India which has details of operational creditors also. So these are the three unique features of the information utility. It is an Indian innovation. It is also a tool which the IPs can use to help him in the insolvency resolution process. We have a software which provides end-to-end case management. We have a virtual data room. So all these tools are there, but I would not, I'd like to stop here, and I'll be there throughout this presentation. I'll be happy to chip in whenever I'm required to do so. So I'm passing it down to Mr. Goyal to continue the proceedings.
Thank you, Mr. Chaudhary. I also would like you to later on to provide some information how the home buyers can take benefit out of this information utility. So because since there is a requirement that at least 100 home buyers are required, so in case they simply file Form C on the Form C of IU regulations, and if they file it online, and would that help rather than collating all the 100 or more than 100 people and taking their documents? That's something that I feel that that's a very, very tardy process, that more than 100 home buyers are required for a commencement of an insolvency of a real estate developer. But in case the IU can help them, in case each home buyer provide information to IU, information of default, so then I believe more than 100 defaults can be accumulated and the application can be filed simply based on the IU records. Is it possible, Mr. Chaudhary?
Yeah, it should be possible. We'll work out the details offline, but it should be possible.
Great. So I will share my PPT in this case. Ankit will also keep noting the questions. In between, we will take some questions also. Maybe there are 2 sessions. And anywhere, Ankit, you would like to chip in, please chip in, because I think you also would be having. So we'll start like as we regularly start, but then in this particular session, since we have to finish it in 1 hour, we only would say that this is these are the topics that we are going to cover in today's webinar: preview of IU and IBC process to register a debt under IBC and its validation, relevant provisions under the Insolvency and Bankruptcy Code, and proposed amendments and case laws. That is the total subjects that we would like to take. As far as the preview is concerned, I think it is this, as Mr. Chaudhary says, that this is it's a new concept. It's a purely Indian concept, and it basically has been established with few objectives, like it is a data repositories for financial information. It receives, authenticate, and maintain and deliver financial information pertaining to a debtor. So even Section 3, subsection 21 of Insolvency and Bankruptcy Code defines information utility as per Section 210. So in fact, the IBC, when it was promulgated in 2016, it actually carries all the sections regarding information utility, and the regulations kept on adding later on as per the requirements. So when we see this, when the ecosystem of the insolvency law, it provides the 4 pillars, and this is one of the pillar. The IU is one of the pillar of the IBC. The first class is the insolvency professionals, and the second is the new institution that has been created out of IBC is the information utility. Then third is the adjudicating authority, appellate authority, NCLT or DRT, and the fourth is the regulator, that is the IBBI. So within these 4 pillars which has been created, IU is one part of it. So this actually provides undisputed information for commencing any insolvency process. It helps filing an application for default, and it actually can provide you a very speedier resolution or a speedier admittance of your application in case we have the record of default on IU. So see, like, I will not spend much time on all these various things. Like here, I would like to give again indulgence to Mr. Chaudhary on this particular slide. Like when we see the advantages of information utility for financial creditors, for operational creditors, and for the professionals like us, like the resolution professional or the liquidators. So because see, you have been speaking on this particular subject very often, so you would actually be able to convey it in a very simple and quick manner. Mr. Chaudhary, please.
Yeah, thank you. So it's been very well put out in the slide itself. Financial creditors' advantages, of course, it is the authenticated information. A very important point was made in the previous slide. IU provides a two-way communication. And that again, that's why it's so distinct from that any other credit repository. So here, and I also use the word equitable. So the debtor gets an opportunity to disagree with any terms and conditions of the debt or the debt itself. Why it is useful for financial creditors? So when the debt is standard, that point itself, if he has opinion of the debtor on any clauses which are not agreeable to him, interest rate not agreeable, quantum not agreeable, so it is helpful for him to rectify the same, because when the default happens, the debtor is unlikely to cooperate. But if you submit the information when it is standard and you get the opinion of the debtor, then you have an opportunity to rectify the same before the account shows some stress. So that is why it's very useful from the financial creditor point of view. And in case the debtor chooses not to respond to it at a later date, as we saw in the judgment, he cannot dispute the existence of a debt. So it's why for financial creditors, it's very important. And it's also a kind of balance confirmation. All financial creditors, banks have to take a kind of balance confirmation. The information presented also has the balance. So it is also a confirmation of the balance. For operational creditors, it's slightly less used. But again, it is extremely important, and we found in a few very high profile cases, it has helped small operational creditors to recover their dues. I know objective of IBC is not recovery, but at the same time, MSMEs face a huge challenge in recovery of their dues. Remember, the way the IU works is, if a default is reported by a small creditor against a large corporate, after IU does the process of authentication and verification from the debtor, a default notification goes to all creditors. Now, such a notification is usually enough to bring the large corporate debtor to settle with the small MSME supplier. So in fact, we are already working with the Ministry of MSME to bring MSME suppliers to use this facility of IU and to ensure that there is timely payment and it helps the entire ecosystem. The third column is how does it benefit resolution professional? Now, at various points of time, we have some judgments, and there could be legal issues where a particular claim is not considered. Now, you do a public announcement. So a creditor has not filed his claim. Later on, when the resolution plan is approved, then you find various creditors, especially government departments, going to court and saying that our claims have not been taken care of. And of course, you may be right, but this leads to unnecessary litigation and delay in the process. Now, if you are using the IU for claim verification, you will get to know that how many creditors have submitted or have debt in respect of that debtor, have provided credit to the debtor. So based on that, you are aware that there could be so many claimants against the debtor. If you find that any of those creditors have not filed their claims, you can approach them that please file your claims since you already have since you already lent to the debtor. So it helps to avoid unnecessary litigation. And of course, storage of information is already mentioned. The IU is a regulated institution. If you are storing the facilities, you have that comfort that it is safe, because you have in many cases personal information of creditors. So if this information comes out, you could have personal liability in such cases. So that is why it is helpful to have your records stored in a safe place like in the IU. It's also mentioned about this end-to-end CIRP solution right from the time of giving the notice from the official creditor to the time of liquidation under auction under liquidation. This entire end-to-end processes can be done through IU. Similarly, regulatory submissions to COC, IPA, IBDI, the CIRP forms can all be generated through the case management system. So you don't have to prepare it manually. And of course, as I said earlier, it is an end-to-end process. Even the auction platform, auction under liquidation can also be done through this. And most important, when you're dealing with the IU, is you're dealing with a regulated institution. So you'll be complying with all the provisions of the code. And we know that it is a time-bound process for every event. There's a time provided in the CIRP regulations. So our system is fully compliant with that. It gives you reminders if an event which has to be completed by a certain time frame is not completed. So all in all, it is a very, very useful and helpful tool for the IP as well.
Thank you, Mr. Chaudhary. I think we'll take it forward. So the information utilities under the Insolvency and Bankruptcy Code, it is regulated by IBBI, and these are the compliances that we are supposed to do is the IBBI and the Information Utility Regulations 2017, and it is guided by IBBI Information Utility Technical Standards. So like in case we see, these are the section 209 to 216, which are pertaining to IU in the IBC. And when we see this section wise, I don't think that we'll spend a little more time, but the only one wanted to tell our audience that the information utility, all these sections, in fact, basically these sections are under IBC and the regulations are also being made by IBBI. So these are all regarding the who can become insolvency information utility, what are the registration formalities for information utility. Then the appeal also can be the appellate authority for any dispute regarding information utilities. Again, the NCLAT governing board is to be made. Core services is also defined. Obligations of IU is also defined under section 214. Procedure for submission is very, very important. Now, when we see the section 215 and then we see subsection 2, it says that the financial creditor shall submit financial information and information relating to assets in relation to which any security interest has been created in such form and manner as may be specified by the regulations. Second, the third is an operational creditor may submit financial information to the information utility in such form and manner as may be specified. So this is where the proposed amendment is happening. This subsection 3 instead of may submit, it also will have shall submit. So it will be mandatory for the financial creditors as well as operational creditors to submit information of debt and default on the information utility. I need to ask one question to Mr. Chaudhary. In case a financial creditor does not submit the information, is there any penalty? Is there any RBI action on the financial institutions like the banks, NBFCs, ARCs? I just want to understand like how the financial creditors are supposed to comply with this section of 215 in case there is no penalty, in case RBI is not imposing any penalty. So what is your thought about it?
Yeah, so RBI has issued instructions in 2017, then followed up with DO letters in 2019, and recently also they have issued instructions to banks. But as of now, there's no penalty provision, but there's an RBI SSM stationed in large banks, and as part of the supervisory review mechanism of banks, so this aspect is also looked at. So it is right now no penalty provision, but in general we find that at least for scheduled banks, there's a fairly high degree of compliance. And recently now cooperative banks which have come under the regulatory regimen of RBI. So even cooperative banks have started submitting information to the information utility. So there's a fairly high degree of compliance, and so far there are no penalty provisions. And so far, since the compliance has been fairly good, so there has been no requirement to take resort to such measures.
So how do we compare with the central registry under SARFAESI and IU under IBC? How do you compare between these two? And the financial creditors are under obligation under section 26 capital E of SARFAESI. They are supposed to file, and in case they don't file their information, their security interest can be subservient. Right. And in case they file this information under section 26 capital E of SARFAESI, then nobody can have a better lien than the secured financial creditor. Right. Like, is there any such law regarding IU also, that in case the security interest is informed and registered with IU, then it becomes a lien which is the best kind of lien on the asset? Yes, please.
Yeah, so I agree with you. There's a bit of overlap between the functions of the CIRSAI and the IU, but CIRSAI is only for secured debt, whereas IU is for all kinds of debt, whether it's secured, unsecured. So it's all kinds of debt. So from that point of view, there's not much of difference. And as of now, IU does not really perform this function of determining who has priority to the debt. But IU does maintain the history of all submissions which have happened, and that can be used to determine priority of debt. Now, since you posed this question, so I would just like to expand this to the digital document execution. As you know, this is becoming very, very popular, and I'll just give you the background behind this. If you see, IU is one repository where submission for documents is also provided for. Again, in fact, I did not say this in the beginning because I thought I'll cover this during the course of the presentation. If you see the Form C, for which is used for submission information, there's a provision for submission of documents also. So that again is a distinguishing feature in the IU. And that I would say is another difference between the CIRSAI and the IU. IU has provision for submission of documents. CIRSAI has only provisions for submission of details. Now, if you talk of documents, initially scanned copy of documents were being submitted, but we had a certain amount of discomfort with it because scanned documents, we cannot verify the authenticity. So IU has now launched a digital document execution, and more than 15 lakh documents have been executed on this platform. So the idea here is that IU will not just have the information of debt, IU will also have the evidence of debt by means of a digital document execution. And this is a digitally signed, sealed, and tamper-proof way of evidence of debt. So that is a further extension of the services of the IU.
This is a very good facility that you are offering to the borrowers and lenders, that they can execute the documentation on the IU. So, like,
So one thing to add here, in the recent budget, there is a proposed amendment in the GST Act, which talks about how if the service provider and the service recipient, or the the supplier and the recipient, they both agree, then that data of e-invoices and the entire supply data can be shared with a third party. And if I imagine, that can be the IU, that can be other agencies, which can then provide this data of actual transactions happening between two parties to various agencies. Agencies like, of course, it can be a proof that yes, this supply happened and there is no dispute there. The goods were received in good quality, all that can be recorded there. Also, then it can open the doors to transaction-based financing. So I believe all that is something that IU will also facilitate in the due course of time.
Yes, of course. This opens up a lot of other possibilities. But incidentally, government is also an operational creditor. So, and in recent past, we have seen in various cases, governments government dues have not been filed, and then they have not been recognized, and they have been, they have taken it up after approval of resolution plan. So in Binani Cements also, there was a very famous case. I think it was GST dues. So now we're also taking up with the government also to file dues in the information utility. So their claims can also be taken up at the beginning itself by the IP when he's comparing the records of the IP.
So I think the IU can also become that third party as per the proposed finance act.
Yes.
I think that also can be done.
Yeah.
So what is the, see, like in case I just take the PSUs, public sector banks,
right.
So what is the percentage of registrations as compared to their total numbers of loan cases?
Actually, we take debt under three segments: in the corporate segment, and the OC segment, and the personal segment.
Okay.
So if you see the corporate segment, by our estimates, I think almost entire this corporate segment is there. And one reason is that a major motivation for banks to submit in the corporate segment is that its IBC has been notified only in the corporate segment. Yeah. Of course, what we tell the banks, and which is true also, even in the other segments also, the benefits of submission to the IU, like this default notification, this ROD certificate. So all those benefits are still there. So that's why if you see the data, in fact, we have a slide here, and we find that even in the personal segment and the other corporate enterprise segment, which are basically partnership and proprietorship firm, there also we have a fairly large amount of data which has been submitted by banks, and they are getting the benefits of submission like this default broadcast, which warned them of incipient stress in the data.
Thank you, Mr. Chaudhary. So going ahead, section 216 deals with the rights and obligations of the person submitting financial information. Now we deal with the other sections of IBC where the information utility is referred. Number section 7, it is very well provided there that the furnishing a copy of record of default, which is called ROD. ROD, if the record of default is submitted with an IU, and that's what it is there. However, as far as the present scenario is concerned, or any other document. So in case presently, in case the ROD, record of default, is not available on IU, then any other record can be presented. In section 9 also, furnishing a copy of any record with IU confirming that there is no payment of an unpaid operational debt. This is also presently available in section 9, but it is also, other options are also available, so it's not much in use. Similarly, section 5, rule 5, sub rule 3 of the IBBI application to adjudicating authority rules 2016 requires that a copy of demand notice or invoice demanding payment by an operational creditor shall be filed with an IU, if any. So these are the provisions where the IBC has already have information utility as a role. However, in the proposed amendment, this role is actually getting almost mandatory, and only very, very few situations where the adjudicating authority will look at other records if the IU records are not available or IU is not capable of taking those kind of records. Similarly, the CIRP regulations actually enables to access the records and also the records of that company on IU. Regulation 7-21 of the CIRP regulation also enables creditor to prove the existence of debt based on the records available with an IU. And in liquidation also, the liquidation estate will have all the assets where the ownership is evidenced from an IU. Now, what it can be like in case there are debtors. In case there are debtors and that information is available on IU, if it is not available in the balance sheet, but it is available in IU, that has to be considered as part of the liquidation estate. Accessing the information on IU, that also, and also for claim verification between regulation 17 to 20, it actually can use the IU. In individual insolvency also, where the debt for which an application has been filed by a creditor registered with an IU, the debtor shall not be entitled to dispute the validity of such debt. This is also provided in the individual insolvency resolution process. So now these are the proposed changes. As I said, that the January 1823, as per the notice issued by Ministry of Corporate Affairs, the proposed changes are increasing reliance on the records submitted with the IU during the admission process. So the section 215 and subsection 2, it is only directory requirement. As far as the operational is concerned, now it is actually being made as the mandatory requirement. Section 7 and 9 provides that in addition to the record of default available with the IU, other evidences can also be, these are the present structure. Now, what is proposed is in section 215, which will be amended in case the after the public comments, in case the ministry thinks, then it will be amended, and it should be where the operational creditor intends to apply to an adjudicating authority to initiate CIRP against a CD, it shall also be required to file the relevant financial information with the IU in advance. So therefore, the section 215 is being amended and to provide a reasonable opportunity to the CD or the debtor to respond to the financial information submitted concerning them, to prevent all that like sleepy kind of debtors from causing delays at this stage. The financial information will be considered authenticated in case the CD or the debtor does not respond within the stipulated period. So this particular part we will understand from Mr. Chaudhary later on in the later slides, like in case somebody doesn't respond, then what are the options available and how that yellow part of the debt confirmation would be handled by the adjudicating authority. So section 9 and 7 also would be amended, where the IU record will almost be mandatory, and for only for a very a different kind of situation, the other records would be admitted. So now we actually can go to procedure to register a debt with an information utility. As we said, NESL is the first and the only IU in India which is approved by IBBI, and this NESL is the first one. It was incorporated on 24th June 2016, and the leading public institutions like State Bank of India, Life Insurance, Canara Bank, Bank of Baroda, ICICI Bank, HDFC Bank, Axis Bank are their shareholders. So this NESL is working towards time-bound resolution and the default intimation to the creditors, mitigation of information asymmetry between the parties to the debt, superior credit monitoring by creditors, and an agreed statement of outstanding balance between the parties. And this facilitates the stakeholders of the IBC ecosystem by leveraging information technology to achieve objectives of the code. Now let us understand who can register a transaction with IU. As per IBC, financial and operational data, both can be registered. Both can register a transaction with IU. There is a process. There is a fee for registration of a transaction. So what is the fee nowadays for registering one transaction, Mr. Chaudhary?
Yeah. So just to clarify, first there's a registration process. Registration is free of cost.
Okay.
No charges for registration, and for submission of documents there is the fee. And if it's for one transaction, if it's operational creditor, it is rupees 60. And if it's for financial creditors, it is 300 rupees. And if you have multiple records, there's a scale-wise charges which are there on the website.
Okay. Okay.
The more number of records you submit, the lesser it comes down. The lesser the per record cost.
So this, I think this cost is very, very reasonable for a financial institution. For one transaction, 300 rupees. For an operational that it is 60 rupees. And if there are multiple transactions, like for the banks, if somebody is uploading, say 1,000 transactions, that may be a different scale for the bulk transaction uploading. And I believe on the IU platform, there is a separate process for uploading bulk transactions.
Yes, yes. It is a seamless process. No manual intervention is required. It happens through file transfer process. And so, if you want to submit one record, then there's a screen-based way of submitting. And there's a payment gateway also. So you can pay for whatever record you want to submit and accordingly submit the data.
So the process, as I understand, is first of all, the user of the NESL services will register themselves with the NESL, and as you said, there is no fee for registration. They have a form which will be, the form will be filled up. It's online form which will be filled up, and the basic information and the identification document, KYC documents would be required. And but then it is written that they pay the requisite fee prescribed by the NESL in advance or maybe agreed to. So what is this fee in the registration process?
Yeah, registration is absolutely free of cost. No cost in the registration, only the fees at the time of submission of documents.
So then you allot actually a unique identifier number to each user. Is that right?
Right. See, the way it happens is we give something called a unique debt identifier. A unique debt identifier is comprised of the PAN number of the debtor along with the account number. So, the way it happens is, now when a bank submits information, so it will submit information, the PAN number of the debtor and the account number. So both combined becomes the UDI. Then when the information is presented to the debtor, so he is able to identify which account based on the UDI. So from the PAN, he'll identify, yes, it's mine. And then from the account number, he'll identify his account number. Accordingly, he'll compare the details and he'll accept or dispute.
So from the simple reading, I could understand that for a user also there is an identifier number. For a user.
Yes. For
a user, there is a unique identifier number. Yeah. And then for a transaction also there is a number.
Yeah, no, let me just clarify it once more. So user is identified by way of his PAN. Okay. If it's a company, the identifier of the user is his PAN. If it's it's PAN is for everyone. In fact, everybody has a PAN. So it's a company, it's an individual, it's a partnership firm. The identifier for the user is always the PAN. But besides that, because a user will have multiple debts. When a bank submits information of a debtor, the debtor has multiple debt accounts. So all those debt accounts will have different UDI. This UDI will comprise of the PAN number, which is constant, and the account number, which will be different for each debt account. So that is how the debtor will identify his account name. He'll see this PAN number. Yes, this PAN is mine. He'll see the account number and see that it's his. And based on that, he can authenticate the information.
Okay, so account means bank account.
Yes.
Account means bank account.
Number. Yes.
And in the case of operational creditor, there may not be a bank account, but there may be a separate way of identifying transactions.
Yeah, so it is basically the contract number. Something unique which the operational creditor gives. Whatever the operational creditor gives will part of the UDI. So when it is presented to the debtor, so the debtor is able to identify it.
So like this was the registration process, registration of a user with the PAN number, registration of a transaction with a unique identifier number. Yeah. And then you're saying that even for separate accounts, there is a separate numbers which are being generated.
Yes.
So now when the information is being submitted by the users, like the financial information as defined in section 3, subsection 13 of the IBC.
Right.
So there are methods which NESL has prescribed for submission of information, like Form C is provided in Regulation 20, and that is for a single transaction or for a multiple transaction, which can be a file, multiple debt, including defaults. So when we talk about other party, a section in Form C, now the other party is the one is the user who is submitting the information, and the other party is the party with whom the transaction has taken place.
Yes, he's a debtor, and similarly, they could be co-applicants, they could be guarantors. So for each party, a separate form is filled in. If you see that form,
for a grantor, separate form.
Yes.
For the
Yes.
borrower, separate form.
yes,
Okay. And the security details, like the any kind of encumbrance on the asset, that also is provided there.
yes,
And it is to be signed digitally with the digital signature.
yes.
So that's very clear. I think the simple process of submission of financial information, which can be multiple files, multiple transactions with one file uploading, multiple forms also, and the unique identifier number will be allocated. PAN number is the number of user. Now, the insolvency professional registration. See, this we'd like to understand the insolvency professional registration. What exactly is this? Why the insolvency professionals should register, and what information they will get out of the registration with IU.
Perfect. Thank you, Mr. Goel, for giving me this opportunity to explain to this. So, information professional for registration purposes, only thing we require is his registration number with IBBI. But for getting access to the debtor in which he's been assigned, if he has taken up assignment as IRP and RP, then we need the copy of the order in which his assignment has happened. So with this assignment, he can have access to all the debt records of the debtor.
Of
So
that
he-
company only. Of
he-
that
yeah,
company only.
Of that company only. So that's because, see, for IU, this issue of privacy and confidentiality is very important. So that is why we ask for the copy of assignment, and he will get access only to that debtor. So he will be able to see all the credit records, all the credit details which have been filed by various creditors, whether it's financial creditors, operational creditors. And very important provision here is he will also be able to see in any debt if the corporate debtor has earlier disputed such claims. So when he is verifying those claims, then he will be alerted that this has been disputed. So this claim I have to be extra cautious. And as I stated earlier, suppose somebody has missed filing his claims. From this records, he can see, then he can approach. Maybe he's not duty bound, but it will help because it will help avoid unnecessary litigation. Then another case, he will also sign. In fact, there's a practical case you will find that many cases, the claims which are filed are much in excess of what are the claims in the IU. So he can then be alerted. He can question the creditors that, look, these are the claims. So it will help him verify the claims. He can question the creditors that this is what you have filed with the IU on so and so date. So what happened after that? That when insolvency is initiated, why have you increased your claims? They may be genuine. They may be genuine, but it gives IPA an effective tool to verify the correctness of the claim.
So that means any kind of assignment, if any insolvency professional is getting, I think the first he should register with the IU
Absolutely.
to know more about the corporate debtor.
Absolutely.
And there is no fee for such registration.
Perfect. I want to say that before that you said, thank you so much. It is absolutely free service.
Oh, great. So I think this is probably being missed out by most of my professional colleagues. And since Mr. Chaudhary, because normally in our webinars, there would be more than 200 people who would be participating, and then it will go to YouTube. And I have seen within about a month's time, more than 1,000 people will further see the video. So I think this, we need to spread around this part, that all the insolvency professionals in each of their assignment, they should register and they should get the information about the corporate data, whatever information is available with IU, and it's free. But even if somebody is not using the facility of PDA, which is a paid facility, this facility is free and it is almost mandatory. You can say that everyone should use it. Is that right? I'm not something which is
absolutely, absolutely. In fact, one more thing I would also say is that this also gives you the kind of security which lenders have given. So one, you can ascertain for yourself which lenders are secured. What are the assets of the company? Any assets, because IP has to take charge of the assets of the company. So all the assets there, is there any assets I have missed out on taking charge?
So then there is a process for verification of the information submitted, financial information, whatever is submitted to IU. The IU has their own system of handling it, rejecting it, or confirming it, or even found missing, invalid, expired. So there are various processes. Error marking processes is also defined there. I'm not going into the detail. Then IU also issues an acknowledgement for each transaction submitted, and then comes is the authentication and the verification of the information, which is again a very, very important part of the discussion today. One, that it has to be submitted with digital registration. Two, that the other party also should confirm again by affixing the digital signatures. In case the other party does not respond, the IU will give them 3 reminders, and in case none of the 3 reminders are reported, then again will be considered as deemed admitted, deemed accepted scenario. So this is where we would need your indulgence. What exactly is the authentication and verification process? Because this is very long, and I would like to be a little brief on this part, because we have many important parts still coming.
Yeah, sure. Yes. So first of all, let me just clarify, there's a different procedure involved for standard loans and default loans. In standard loans, a reminder is sent, and if the borrower, he can still accept on dispute. He can choose, if he chooses to ignore, the record will stay as it is. But in case where default is reported, information of default is reported, so in that case, this issue of deemed, which Anil Goyalji mentioned, that will come in. But that also, in the recent amendment in June 2022, if it's a bank under Schedule 2 of RBI Act, so the concept of deemed has been removed. So in that case, if the IU gives a request to authenticate to the debtor, followed up with 3 reminders with a gap of 3 days each, and at the end of it, if the debtor does not respond, then it will be treated as authenticated, which is green color. So let me just repeat, for banks in Schedule 2, and if it's an information of default, there are only 2 color codes, which is green and red. So if the corporate debtor does not respond to the authentication request, followed by 3 reminders with 3 days each, then it will be treated as authenticated with a green color code. And of course, anytime within those 3 reminders, if he comes forward and records his dispute, then it will be treated as a disputed record with a color code of red. One more issue I would like to bring it to the notice is that when we send the mails, a proper tracing is done of the mail. Mail is sent only to the MCA registered mail or the mail registered by the creditor, and this sequence is provided in the regulations. So this is to ensure that at later date, a debtor cannot say that this mail ID is not mine. So that precaution is taken, and also the tracking of the mail takes place, whether what happened to that mail, when was it delivered, was it opened. So all those are tracked and becomes a part of the credit history of the debtor.
So this slide shows the various statuses of the financial information submitted to IU. One is the not presented, means that it is not yet presented to the third party, although it is instant. So you would not find any such status in the IU. Pending means it is yet to be authenticated. Failed authentication means that the specified time limit of 15 is exceeded and it has expired. Authenticated means that it has been verified from both the parties with the digital signature. Disputed means the other party has disputed or disagrees to a part or the entire information. And deemed to be authenticated is, as Mr. Chaudhary said, that after 3 reminders, it would be deemed to be this. So this is a kind of status that we have for information. Debtor confirm the information of default, authenticated green. Debtor disputes the information of default. This is disputed means red. Debtor does not respond even after 3 reminders. This is deemed to be authenticated yellow. But this part is not where the second schedule of the Reserve Bank of India, it is not applicable to the banks. There is only green and red. One is the debtor confirms the information of default, debtor does not respond. This is all green, and the debtor disputes the information of default. It is red. Exactly what Mr. Chaudhary says is also presented here. So information of default. So as he said, that there is a different process for standard information where the default is not there, and there is a different process of authentication for information of default. And it's almost the same as already informed, because the debtors confirm the default, it is green. Debtor disputes the default, it is red, and debtors does not respond, it's basically the yellow. So one is the basic information and the other is the information of default. Now, I think let us understand the importance of this particular information utility record of default, ROD. So we actually can see the case, which is Vipul Himmatlal Shah versus Teco Industries. That is the judgment which came in May 22 from the Appellate Authority NCL 80. So in this case, the appellant in this case is the directors of the company. They are the appellant. So they actually have disputed that the information utility record have been accepted by the adjudicating authority, and that is what they were disputing. And they are saying that the emails of the directors were used. Email of the Vipul and the Tulsi that was used, but the email of the corporate debtor was not used for sending the information, for getting the confirmation. However, the directors did not dispute the fact of receiving the emails, that they received the emails in the name of the directors and not in the name of the corporate debtor. And they also chose not to reply and send an email and not to forward them to the appropriate address. That's what the background is. So in this case, the observation of the appellate authority was that Regulation 21, Sub-Regulation 3 of the Information Utility Regulation provides that a debtor does not respond even after 3 reminders, the information of default would be deemed to be authenticated. The corporate debtor or its authorized representative did not take any action under the grievance redressal policy under Regulation 12 of the IBBI IU regulations to set the record straight in case it found to be incorrect. On the basis of these facts, the analysis, we could inclined to hold that the corporate debtor cannot deny the existence of financial debt as defined in Section 5, subsection 8 of IBC as present in the records of the information utility, and that particular application what was filed by the directors was rejected and the records of the information utility was accepted. The commencement of CIRP was validated. So this is a very, very big success, that even if the email has gone to the directors, the appellate authority says that it was not shifted, it was not forwarded to the correct, and it was not even. Now, what is this, Mr. Chaudhary, what is this grievance redressal policy under Regulation 12 of the IBBI IU regulations?
Yeah, so we have a grievance redress policy. There's a portal in which you can lodge a grievance. If you have any grievance, you can lodge on this. In this case, he did not use the facility, but incidentally, besides this grievance redressal facility, and he could have also used the important provision of simply, registering and disputing it. So that provision, he had 2 options to him. He could have used the grievance redressal, but very importantly, he could have also, registered on a platform and simply disputed it. Anilji, one very important provision, I'll use this, forum to bring to notice to everyone. This judgment was in a case of application filed by an operational creditor. So information duty can be extremely, extremely useful for operational creditor, which this judgment has proved.
Oh, good. So another case law that we
so I'll quickly take up some questions, I think, because they're related to this discussion. So when we say that the dispute can be raised, can the dispute also be raised after those 3 reminders, or after that there is only an option to raise the grievance?
After that, there's only option to raise the claim.
You can
So
always
have to
raise
do
the
within
only
within the 3 days
So,
only you have to claim.
understood.
See,
This
every law, it cannot be
that's the clarity.
It cannot be
That's the
indefinite.
confirmation I
Yeah.
thought I
Well,
should
only
say.
within that.
Then Vithal, the Hakeji is asking that if a creditor who has filed a claim wants to edit the claim, is it possible to edit his claim?
Always. It is always, you
And
can, it's
once
not
he
creditor, it's not editing. You have
yeah.
to file a fresh claim, then
Okay.
you have to file a fresh information, and that information itself will be taken into cognizance. Because see, the debt record is unique. If a bank is using the PAN number, account number, so the moment you file a fresh record, so that will be taken into cognizance.
No, but I think here he wants to say that, say the bank filed a claim, or rather a creditor filed a claim with respect to an invoice number, or let's say an account number, and later he found that the filing that he made had some error. Maybe the error was with respect to the amount, maybe with some other respect. So is there any process to edit that claim, or he will?
Yeah, I'll tell you. So there's process for error marking. So creditor can error marking. That is one part. And if the creditor does not do it, the debtor can dispute it and give a revised amount.
So in case say let's say I file a claim and say that XYZ owes some money to me, and I file a claim, XYZ gets that claim, and instead of making it, maybe he doesn't dispute online. Now he says that, okay, you correct this, and I want to correct it. So once I correct it, then it will be again going, the corrected amount will be going to the other person for approval then, right? That is how it will work.
Exactly.
Okay. And how do we extend these services to, now this is a question from Elhada ji. He's asking that, how do you extend this to companies outside India? Let's say where there are the debtors of the CD are located outside India. Is there any facility for those people to register where they may not have a PAN because they are not operating in India, or they don't have a registration in India?
So if you do not have a PAN, the technical sites provide for a for the IU to allot the PAN. But for debtors registered outside India, they will not be subject to Indian jurisdictions. So it's a bit difficult to give the benefits of these provisions. But then he can get in touch with us offline. We can help him in that process. There are certain banks like Exim Bank who are filing information, their debtors are overseas. So we've devised a mechanism for them. So we'll try to help out if any creditor has any specific issue. But in general, it would be a bit difficult.
Got it. And if the NCLT, or this is a question from Atul Jain ji, that if the NCLT or NCLAT refuses to recognize a deemed authentication report by IU, then I think there is no alternative but to go to the higher courts. That would be the solution.
So far, it's not happened. So far, it's not happened.
It's not happened so far.
So far, it's not happened.
Yeah, please, let's continue. Yeah.
Good, Ankit. So like almost the time is also finished, but then we can extend it by 10 minutes. If there is any question from the participants, they may ask now. In the meantime, I'm reading the other law, which is IL and FS Infrastructure Debt Fund versus McLeod Russells India Limited. This is again a very, very recent judgment from NCLT Kolkata, and it is dated 10th of February 2023. Very recent. Now, in this case also, it was Section 7 application, which was actually filed by the ILFS, and the CIRP was to be initiated against McLeod Russell India Limited. The debt was the date of default have been stated as 9th of July 2019. Financial creditor recorded the debt with the information utility, and the corporate debtor has been recorded as the debtor therein. So in its report dated 8th of February 2020, the IU being NESL in response to the filing by the FC in Form C recorded the default of the corporate debtor, and because since they were not responding, so it was assigned the color of yellow in the IU portal. So the debt was deemed to be authenticated as the IU had issued 3 reminders email to the corporate debtor, and the corporate debtor failed to issue any response to any of these emails. This is the background, and the submissions were made by the applicant, like the existence of debt is there, occurrence of default is there, and the information utility document is, see, like this is what is the company saying, McLeod, that the information utility document is not a verified claim. The applicant's reliance on this document is inconclusive as a proof of debt. The record of IU is itself subject to verification and cannot be sufficient to establish relationship. IU regulations, in particular Regulation 20 and 21, make it clear that on receipt of information of default, an IU shall expeditiously undertake the process of authentication and verification. So there is a stringent requirement of such regulation. This process was not complied. All these allegations on IU was basically thrown by the. So what are the observations of the NCLT? NCLT says that Section 7 of the code envisages that the adjudicating authority has to ascertain the existence of a default from the records of an IU or on the basis of the other evidences furnished by the financial creditor. Even if the IU record was not appropriate at that time, there was the post-dated checks were also issued by the corporate debtor, and that the information on IU. So therefore, the debt is established, and the fact that the borrower failed to respond is not a ground. Therefore, the adjudicating authority is satisfied that the default has occurred. This was also another success. So now we come to this part, IU for insolvency professionals and submission of information. Now, as far as the first part is concerned, the creditor confirming and the debtor confirming, and then solicit debt information. That's what we've already discussed, that what actually the insolvency professional by registration, what they would get. Now, coming to this, the existing services of the NESL as IU would be credit repository, as we've already known, online registration of the users, information submission, financial information submission, and information authentication. Then the reports like authentication status, authentication behavior, 360-degree report about a particular debtor, record of default, statement of default, online registration module, registration that we've already discussed, the online registration, linking with the debtors and accessing information. What exactly is this part? This is, I couldn't understand, linking with the debtor and accessing information.
And yeah, this is for the IPs, I think. For whatever you stated here, this is for IPs. As we discussed earlier, yeah, so IPs has to give the copy of his assignment. So based on that, we'll link his first, because IP has to first register, including his registration number.
Right.
And once he gets an assignment, so he has to upload the copy of that assignment, and then we'll link him to the corporate debtor, and he'll get all the records in pertaining to the corporate debtor.
So this is the storing information and retrieval. This is again another service. So I think you can talk about this service of PDA and the services that you are providing to the insolvency professionals. And in the meantime, I can stop sharing my PPT.
So we also have some more questions that we can take up. So Suresh Malhotra is asking that, is there any mechanism to verify the dispute raised by the CD, or is it taken on its face value? So this is a very important question, which I think would be on everyone's mind. Yeah. X files a claim against B, Y, and then Y disputes it. So X has filed certain documents, Y has filed some counter documents. Now, how is this dealt with at NESL?
So, NESL is not an, has authority to adjudicate on any debt. So the way it happens is, if there's any dispute, so it has to be settled outside the NESL system. So if once a dispute is recorded, it has to be settled outside the IU system, and then a fresh information is submitted if the dispute is settled. If the dispute is not settled, of course, it has to be decided only by the A, because the NESL cannot take on the role of the A. If there is a dispute, if it cannot be settled between the two parties, of course, the A has to take a view. The idea here, yeah.
So I think, therefore, you keep saying that it is very important for the operational creditors, other creditors, to file the file their dues when the relationship is good.
Exactly.
Because
that is the point. So
yes,
that is precisely the point. So you have to establish a credit history. So if you file information when the going is good, then you ensure, in a supplier, for example, as a supplier, if I'm making a supplier to a debtor, so when I make a supplier, before I make further supplies, I can request him, please authenticate the debt, and I'll make further supplies.
Yes, very important.
That way, you're creating a credit history, and yes. Then now, even assuming he does not, So you then have a credit history that I have supplied to you. I have submitted information for 3 months. And then when I'm presenting a default, and then you're disputing. So that entire credit history, if you build up, and of course, dispute cases, if you cannot settle, it'll go to the A. But if you are able to build up this credit history, then you can have a good case before the A.
So the credit history has to be built up. It has to be kind of, it has to go into the finance departments of the companies. And so that they start building up the credit history, they start submitting the information, financial information to IU. IU is not very expensive. I think the monthly information of supplies can be submitted to IU, monthly information of supply, and that can be a bulk file, and that may not be very, very expensive. So we have seen today that in case this amendment becomes the law, which is proposed as of now, the role of IU is going to be increased. And then, of course, the operational creditors and financial creditors, they would be all very keen to register their financial information with IU. And Ankit, is there any other question, or should we close it?
I am seeing the other questions, but I think that we have mostly discussed that. So one question is that if there is a settlement that happens after the default data was uploaded on NESL, then how will that dealt with? I think it's okay that the idea is that if the settlement is on record in a court order, then you can't use the same information again to your benefit. So the information
I would advise in such cases where the settlement is, a good way is to clean your record in the IU. If your settlement is debtor, the debtor can insist on the creditor that please file a claim, file a fresh claim recording the settlement and the revised amount.
So that can be part of the settlement process.
Yes.
So that the credit history is clean.
So that the credit history is clean.
Yeah, nice. So whether the data is to be submitted to IU for all accounts, healthy NPA accounts, that is what we are exactly talking about. It should be done for all. With respect to the, so Atul ji is giving a feedback, where he's saying that NCLAT is not willing to see IU report. They want the applicant to first establish that he is an FC, and only then they are then dealing with this matter that he has at his hand. So I believe establishing yourself as an FC and establishing that there is a default in the IU report are different issues. They should both be done simultaneously, to my opinion.
Ankit, if it is an actual application under Section 7, so the first thing that the adjudicating authority or the appellate authority needs to see is whether the person is a financial creditor or not. The information utility comes later. First of all, we have to cross the threshold of financial creditor or operational creditor.
Yes,
then
I think
default.
Yeah, I think we are all on the same page there. So this makes sense. That's about it. I think those are the questions that we could take up and which were the important ones.
Anything that you would like to add, Mr. Chaudhary, further to this opportunity that we have today regarding the PTA or regarding the other services?
No, so one is, of course, like I said, this IP service is free of cost. Then the storage is also comes at a very nominal cost. I think I spoke briefly earlier, and it gives you a lot of peace of mind that if you store, you are there, you are storing your records, it will be safe, it is with a regulated entity, it will give you enormous peace of mind. Even after, you can do it on an ongoing basis. You can, whenever the records are there, you can push it there, and you can be safe that it is, it is in a safe place. You will not have any liability on account of it falling into the wrong hands. And of course, we have this case management system. It provides the end-to-end solution right from the time of giving the notice by the operation creditor to the time of auction. So do use the services, and also you pay only for the months you use it. That's all I think. Thank you so much.
So thank you very much, and thank you very much, Mr. Chaudhary. So I think it's a wonderful session that we've had with our audience today, and we are happy that at the last moment we thought about it, and this thought came in the morning at about 9:30, and then I immediately called you, and you in fact nice enough to accept this invitation immediately. So you have added a lot of value to this webinar. Thank you very much, Mr. Chaudhary, and thank you all the participants for remain connected with us. So we are continuing our efforts. So we have a kind of thought process that every week we will be presenting a new subject, and we are not going to repeat any subject any week. Thank you. Thank you, Jay.
Okay, thank you. Thank you all participants. Thank you, Anilji. Thank you, Ankitji.
Thank you, Mr. Chaudhary, for joining us. Thank you, all the participants. Thank you.
Thank you.